Good afternoon, ladies and gentlemen. There are students, friends from mediation field coming, and colleagues as well. Thank you very much to be here on a pretty cold afternoon. Thank you for bringing in the warmth. Now, before I begin with introducing Professor Aughterson, I'd like to say a few words about this project. So back in 2015, a team of dedicated colleagues, Dr. Hu, our deputy president included, has started to plan to apply for research funding under the Research Grant Council, under the Institutional Development Scheme, IDS, and successfully get a fund in establishing a funding for 3 strategic areas for research. First, brain-based teaching and learning. Second, decision-making. And finally, negotiation and persuasion. Coming into the 3rd year now, we have already conducted, I think, about 25 seminars, workshops, lectures on brain-based and teaching and learning, decision-making. And this year, we come to negotiation and persuasion. And of course, one major area will be mediation as well. So this year, we'll endeavour to promote negotiation and persuasion in this IDS project. We're very honoured this year. We kick off by inviting Professor Aughterson to our university. And of course, Professor Aughterson is not new here. He's been with HKSYU in 2007 to 2011 as the department head of the Department of Law and Business. And currently, he's the head of the School of Law at Charles Darwin University in Australia, as well as our emeritus professor here in HKSYU. Now, having a professorship in a law school, Professor Aughterson is also a barrister in practice, having appeared before the court in several of Australian states and territories. He's also representing in the High Court of Australia as well. Besides a practice of appearing in court, is also a seasoned mediator handling cases, not just of a commercial basis, but also of a community basis. So today we'd like to share with him some experience and approaches to mediation. Now in Hong Kong, we're doing a facilitative mode of mediation, but is it the only mode? Can we adapt more different approaches to mediation in Hong Kong as well? So hopefully Professor Aughtorson's experience will shed light on our way forward. So before we let Professor speak, I'd like to invite Professor Sun, our academic Vice President, to present a souvenir to Professor Aughterson. Would Professor Aughterson please come forward? Thank you so much. So without further ado, may I invite you to join me in giving Professor Aughterson a big applause for his speech on a lecture on mediation.
Well, thank you for that warm welcome. I was at dinner yesterday evening with colleagues in the Department of Law and Business, and also with some of our ex-students who have gone on to do wonderful things, some of whom are now lawyers. And I made the observation that coming back to Hong Kong and coming back to HKSYU is like coming home, and certainly it is. But whenever one comes home, of course, there are things to do, and my task today is a happy one, is to talk to you about mediation. And it's a topic that I have a good deal of interest in. I have practiced as a mediator. I've also taught in mediation courses. But also, as Wendy says, I've also been in practice as a barrister. And in Australia, it's not uncommon for barristers to also be mediators. And I, to be mediators, not only mediators, but also to appear as representatives of parties. It's quite common in Australia for the bigger mediations for the parties to be legally represented. So you might have a room full of parties, because there can be several parties to a mediation, and with them a room full of lawyers. So it's an interesting experience being a barrister who is supporting one of the parties and watching somebody else conduct the mediation, and that in itself is a learning experience, because mediators approach the task quite differently, and you can learn a lot simply by observing how others do it. So thank you for allowing me to be here today, and thank you to Professor Sun for inviting me, but also thank you for the hospitality I've been given here, and Wendy and has been very hospitable, but also Jay and Joanna have been very helpful. So I appreciate the wonderful welcome that the welcome one always gets when one comes to HKSYU University. So I very much appreciate that. Now, yeah, sorry, it's too close. Isn't it?
Yeah, too close.
Oh.
It might be better.
Okay. What I want to do is to talk generally about mediation. As I said, I'm very positive about the virtues of mediations, but I'm not blind to the fact that there are also shortcomings, there are limitations. And in part, those limitations arise from the way that it's used. So I want to start by saying that there are two fundamental reasons why I think mediation is the best path. And the first one is that in contrast to litigation or arbitration, there is less blood on the floor at the end of a mediation as distinct from litigation. It's a much easier process on the parties. The problem with litigation, or one of the problems with litigation, is that it can be protracted. It can take place over even years. And during that passage of time, the parties, by virtue of the nature of the proceedings, tend to be very antagonistic to one another. And it's very hard at the end of that process to maintain any relationship that existed prior to the dispute. It's very hard to recover in circumstances where the parties have been attacking each other for a couple of years, because often quite nasty things are said by one party about the other. The other major reason why I think it's a very good process is because there's a fairly good chance that at the end there'll be an outcome that's acceptable to both parties. As Wendy says, I've also for many years practiced as a barrister, and I still practice as a barrister. And it can be very soul-wrenching for parties to litigation to come out of court and to lose. And also, always with litigation, almost always with litigation, one party loses. And very often they feel that they have been done badly. And perhaps they have, sometimes they have, because the difficulty, of course, is that judges are human beings, and judges, like the rest of us, make mistakes. They get it wrong. and that not infrequently happens. And of course, that can protract the problem, because then the parties talk about appeals, and then the whole process starts over again. So what I want to start with, that's all right, is just to give you an overview of the things I'm going to be talking about. First of all, I want to say something about what mediation is. I'm conscious that not everyone in this audience will be familiar with mediation, so it's necessary for me to say something about that in order to give context to the observations I want to make later about the virtues or otherwise of mediations and the different types of mediation. So first of all, I want to talk broadly about how it works, and second, I want to say something about mediation models and styles, because rarely in life is there only one way of doing things. And when you were saying the approach here tends to be a facilitative approach, but there are other ways that you can conduct mediation. So I want to say a little bit about those. And then thirdly, I want to say something about the advantages of mediation. I've already mentioned a couple of factors, but I want to say a little bit more about the advantages of mediation, but also the limitations. And in relation to limitations, it's often not so much the limitation of the process itself or the concept of mediation. The limitation comes often from the way it's conducted, but also there have been problems in other jurisdictions, and I'm not really familiar with what happens in Hong Kong, though I was speaking to somebody last night, in fact one of our ex-students who's now a lawyer, who was giving me some advice on the mediation process in Hong Kong. But I know in some jurisdictions there are problems with court-ordered mediations, and court-ordered where mediation is ordered by the court, where litigation starts and the judge says this should be mediated and insists or suggests that it be sent off to mediations. And there are problems with those court-ordered mediations in some jurisdictions. And fourthly, I'll say something about who generally mediates. And in a lot of jurisdictions it tends to be lawyers, and I'll say something about why that tends to be the case. But certainly it's not the case that lawyers should always, at least, be conducting mediations. And then fifthly, I want to say something about alternatives, because other concepts emerge, as they always do. Other ways of doing things are tried, and that is certainly true in this area. And one of the things I want to talk about is what's called collaborative law, which is mediation without a mediator, if that makes sense. But I'll come back to that. So the first thing I want to talk about is what is mediation and how it works. And this is just a very general background overview. I'm not purporting to give you a course in mediation. It's just to put in context the sort of observations I want to make later. But the essence, of course, of mediation, the idea of mediation, is about settling disputes. And certainly, ever since people have walked on this planet, and I imagine for as long as they continue to walk on this planet, there'll be disputes. There'll be disputes between individuals, and with civilization, with the advent of civilization, there are disputes between organisations and disputes between states. And very broadly, there have tended to be three ways to address those disputes or to resolve those disputes. The first one is by the parties simply talking to one another and trying to resolve their differences. The second way is by adjudication, by having somebody come in, listen to the stories and then making a decision as to how that dispute should be settled. And in prehistoric times, it was probably done by tribal elders or later on by community groups. And to some extent you still see that. But these days adjudication, formal adjudication is by the courts and tribunals and by arbitrators. And then the third way, of course, that people have settled disputes is through aggression. And the ultimate evidence of that is through warfare, through people simply going into, or states going into combat. Now, mediation, of course, is a branch of that first method, the first method which is people coming together and talking. And mediation is an extension of that, because what you have is you have a mediator, a third party coming in and assisting the parties to mediate. That's their job. It's not to take control, it's not to adjudicate, it's not to make a decision on behalf of the parties, it's not even to advise them as to what their decision should be. It's simply to facilitate, and hence the classic form of mediation was facilitative mediation. But fundamentally, that is the role of mediation. It is simply a process whereby a third party comes in, brings the parties together, gets them to talk about their problems or their issues, and then helps them to reach a settlement. Now it's fairly easily stated, but of course, as with all things, it tends to be more complex than that. The important thing to keep in mind with mediation is not only does the mediator not intervene in the decision making, they've got no authority to do it. They're not given authority by the parties to do that. Certainly with bigger mediations, and it's certainly the case where I come from in Australia, that you'll have a mediation agreement, a written mediation agreement which the parties will sign, and that'll clearly set out not only the rights and obligations of the parties to the mediation, but the processes that will be involved, and they invariably make it clear that the mediator will not give advice and the mediator will not make any decisions. That is purely for the parties. So you have this role of the mediator who is there to assist, and basically that's it. And it's sometimes said that the sign of a very good mediator, is when the parties walk out of the mediation and their dispute is settled and they say to one another, we didn't need the mediator, we did that by ourselves. And when they say that, you know that the mediator's been excellent because they've taken that back seat and allowed the parties to reach their own decision, because that's one of the great virtues of mediation, is that the parties own the decision. It is their decision. And if you own something, if it's your idea, it's much more likely you're going to stick with it. Much more likely that you'll observe the terms of the agreement that you reached. So what I want to talk about next is I want to move to the second issue, which is models and styles, mediation models and styles. And these days, there are any number of mediation courses available. I understand it's the same in Hong Kong, that there's no shortage of mediation courses you can attend. They still tend to be intensive courses in most jurisdictions, rather than the sort of courses that you're doing at this university. They tend to be intensives. And in essence, what they do is they propose a model. They give you a structure. They give you a structure to assist you in carrying out your mediation. And the other thing they do is to suggest the sort of language you should use. And the language you should use as a mediator is important, because remember, what you're trying to do is bring two people together. You don't want people to come into a room to mediate and they just shout at one another. While parties are in that sort of combative position, they're not going to agree to anything. It's fine if they start out that way, and sometimes it's necessary. It's necessary for people to get things off their chest. But the mediator has to control that. It's important that they control that in order to enable the mediation to move on. So the basic assumption underlying most models, not all of them, but most models, the basic assumption is that the parties want to settle. Because if they don't want to settle, they wouldn't be there. Normally, they wouldn't be there. Now, I have to make a distinction there with court-ordered mediations, because where a court orders a mediation, sometimes the parties don't want to be there. And they're there only because a court has told them to be there. And that is one of the limitations. I'll come back to that later. I don't know how we do we. Is that me? Was that the?
Because it's too close.
Is that? Yeah.
That mute.
Or maybe even down there. It's still picking up. Okay. Okay. Thanks. In a moment, I just want to take you through a popular model. It's not the only model that is used, but it's a popular model in most jurisdictions for mediations. And the only other preliminary observation I want to make is that the focus always is on interests, what's called interests, rather than rights. Litigation deals with people's legal rights. That's all it deals with. It doesn't deal with wider issues that might concern the parties in dispute. All a court can do is look at your legal rights and obligations and make a decision. They look at the facts of the case, they make a decision based on the facts and the law. And that's all ever a court can do. Whereas what mediation can do is look at non-legal solutions. The sort of solutions a court can't order. There are lots of examples of that arise, but a simple example is one solution sometimes to commercial disputes is the continuation of the commercial relationship between the disputing parties. And sometimes a settlement involves them working together in the future in a cooperative way. Now, a court can never make that sort of order. There's no authority in a court under our legal system. When I say our legal system, I include the Hong Kong legal system, that would allow a court to compel people to work together. but through mediation, the parties can enter into a binding agreement between themselves to do just that. So can I go to that model? How do I? Yep, thanks. All right, now, those who have done mediations would have seen models just like this. If it's not identical, it's very simple. And if you look at it, it's in two halves. You know, oh, what have I done? Pushed the wrong button. My children say I should never be allowed near technology. That one. Aha, I've got it. Okay. So if you look at this outline, that top half there is supposed to be devoted to the parties understanding the problem in a very broad sense, whereas the bottom half of the diagram is the steps that you're supposed to take in solving the problem. Now, at the top there it says pre-mediation. So I just want to take you briefly through these steps. And again, just for context for things I want to say later on. Now, pre-mediation is something that happens, as the name suggests, prior to the mediation starting. And it's always very useful, particularly in bigger mediations, for the mediator to get together informally with the parties prior to the day on which the mediation takes place. And there are a number of reasons for that. One is it's important that the parties understand the ground rules for the mediation, that they understand what the process will be, so they're not surprised when they get there on the day. So it's very important that's made clear to them. If lawyers are involved representing the parties, you've got to make sure the lawyers understand that they have to behave when they're at the mediation and not be lawyers, and not to act as lawyers traditionally behave. And there are other things that you would raise at that time, including whether the parties have authority to reach an agreement, because these days often mediations involve corporations or governments. And in fact, a number of the mediations I do when I represent parties is I represent the state government in mediation. So the mediator has to ensure that you, as the representative of that party, have authority to make decisions, that in effect you stand in the shoes of the party. And what's common in Australia these days is for the parties to write a position paper before they get to the mediation, where they write out a story, if you like, saying what they think the issues are, what they think the matters in dispute are, and saying something about their attitude, if you like, in relation to those matters. And then what happens is when you get there, the first thing that happens is you all get together. I should say that you'll see there written where they talk about private sessions and joint negotiations. It's common in any mediation to have 3 rooms. So you have the main room where the mediator meets with the parties, and then you'll have 2 separate rooms where the parties can retreat to, if you like, or during breaks they can go to. But also, if you're having a private session with one of the parties in the absence of the other, they've got somewhere to go. So what happens is normally when you start in those early stages up to there, those first 4 stages, you're in a joint session. You're all in the room together. And then it's really a question of what you do next. Now, this model suggests what you do next. It suggests you have an opening, then it suggests parties give their statements, and then there's reflection, and then there's exploration of issues. Now, as I said, it's a model, okay? These things are not absolute. They're there for guidance, and I'll say more about that later. But the opening is usually where the mediator gets to speak. And perhaps what they're doing is repeating what they've said at the pre-mediation conference. Again, just to make sure the parties understand the ground rules. The second step on that chart is the parties' statements. And this is where the parties tell their story. And that's what it is. It's a bit like counsel addressing a jury, and you've probably all seen enough TV shows and films of counsel addressing juries. They're always exaggerated, but you get the idea. It's somebody telling a story. In this case, it's the parties telling the story about their case, obviously from their position. And so they set out what their position is, what they think factually are the rights and wrongs of the situation. And if they're smart, they'll also say what the weaknesses of their case are. And it's the same in relation to litigation. As a barrister, when you're in court, it's always best for you to say what the weaknesses of your case are. It's better coming from your mouth than from your opponent's mouth. Your opponent's much likely to be much more antagonistic when they're setting out the weaknesses of your case, and probably much more graphic in their description of the weaknesses of your case. Whereas if you say it yourself, you can at least put your slant on it. And also what happens in a mediation, very often it takes the other party by surprise because they don't expect you to be making concessions. And sometimes what even happens is that they take the approach you have taken on board, and then when it comes to their turn, they think, all right, well, maybe I've got to make some admissions as well. And so they make concessions. And once you have parties making concessions, you're starting to get the foundation for agreement, because it's a party conceding not all the right is on their side. And in itself, that's suggesting that there's some room for movement, some room for agreement. What's important in the joint sessions, and a mediator will emphasise this, is that the parties talk to one another. They don't talk through the mediator. And if they do, the mediator should suggest to them, here's the party there, talk to one another. Remembering that the mediator is just a facilitator. And these can be very revealing, these parties' statements, because sometimes it's the first time the other party has heard their story. They might have heard their story in legal terms, through legal jargon and claims made in court, but they haven't necessarily heard the real story. And sometimes it's the case that the parties haven't spoken to each other since their dispute arose. So it can be helpful not only for the person telling the story, because it gets things off their chest, and that in itself can be healing. The fact that you're telling an audience what has concerned you, that in itself can be healing. But it also can be helpful to the other side to hear that. But it depends again on the nature of the dispute. If you have a commercial dispute between two seasoned commercial entities, they're not much interested in your personal feelings.
not much interested in it. What they want to do is reach an agreement and get out of there. So again, a mediator has to be sensitive to that sort of thing and has to control the mediation. But the important thing for the mediator in this early stage, in these opening statements, is to make sure that the parties don't dig a hole for themselves, that they don't become so het up and antagonistic that they're no longer in any framework where they can agree to anything. And also, if they're overly antagonistic to the other party's not going to be in a mind to settle because they're going to be offended. So that is certainly a difficult job at this early stage, to keep that balance between allowing the parties to get things off their chest, but at the same time not letting it go too far. And that's not easy. And then once the parties have made their statement, it says here it's reflection, exploration of issues. What tends to happen then is this discussion. So the mediator might say, well, look, there are 3 issues that you've raised here. Let's talk about them. Let's talk about this first issue here. So you're still nutting it out. And you might say to the one party, look, you heard what person A said. Do you want to respond to that? Have you got anything you want to say about that? So it's still just encouraging the parties to talk. And then hopefully through that there'll be a fuller understanding of the issues on both sides, and then you can start moving slowly towards exploration of those issues, exploring possible remedies. You don't want to move too quickly to that, but again, depending on the nature of the mediation, but the parties then start to, in that joint session, start to explore not necessarily final solutions, but the stepping stones to how they can move forward in resolving their dispute. And then what happens usually, the mediator will sense, well, look, we've gone as far as we can with this. It's probably productive to talk to the parties separately. So they'll say, well, look, I'll talk to the parties one at a time. One party will leave and the other party will stay, assuming there's only 2 parties to the dispute. And here is the opportunity for the mediator to raise things or to allow the parties to raise things that they're not yet prepared to say in this joint session. They're not yet prepared to reveal to the other side. It might be stuff that's a little bit confidential. It might be that they want to test their ideas with the mediator and get a reaction from the mediator. They might want some feedback. But this is a great opportunity here for the mediator to test the position of the parties. And this comes back a little bit to what I'll say later on about the different styles of mediation, and depending on the style of mediation adopted, some mediators will go further than others in this next stage. But in all mediations, pretty well all mediations, there'll be what's called reality testing. They'll talk to the parties about whether or not their position is realistic or not. They won't give them advice. They won't say, well, I think it's realistic, or I don't think it's realistic. They won't say that, but they'll encourage the parties to think about that. They'll encourage them to think about the advantages of agreement and the disadvantages of not agreeing. So they could say to them, well, look, if you don't, let's assume you don't agree today, what's the best outcome you'll get if this proceeds to litigation? What do you hope to get? What do you think you can get? Or the converse of that. If you don't agree today, if this does go through to litigation, what's the worst thing that could happen? What's the worst result? And sometimes that gets them thinking at least about the sort of range of options open to them. You know, what's the worst case for them? What's the best case? Well, maybe the solution's somewhere in the middle there. They're probably not going to get everything they want, but somewhere in the middle. And there's also a chance for some reverse psychology by simply saying to the parties, well, look, you know, what do you think? Why do you think the other party takes the attitude they do? You've got to be careful, of course, with that. They might give you an answer you don't want. They might say because they're a fool, they're stupid, you know. But at least, again, it gives them the opportunity to think outside the square a bit, to think a little bit more about not only their position, but also the position of the other party. So you can go through that process, and then you talk to the other side, and you might, you know, go through the same sort of analysis, same sort of questions. And then you might meet with the other party again. You know, you might have several of these joint meetings going back and forth. But then eventually, hopefully, you'll reach the stage where you think, look, there's probably some prospect we can settle this, bring the parties back in together again, so the parties come back in together, and that's then at that stage where it says joint negotiations. But you don't do that normally as a mediator unless you're confident that the parties are in that square where they're ready to start bargaining. And maybe once you're into that for 5 minutes, you'll realise, well, maybe they're not quite ready. I thought they were, but they're not. So then you might say, well, look, let's go back to private sessions again, and then you'll start talking them together and say, look, what's the block? What's the problem? So this is a process that can be followed. It's not exactly on that sort of formula, but as a guide, that's the sort of framework. And then you get to, on that framework, you get to the agreement, hopefully, and closure. And then at the bottom there it says post-mediation. So hopefully you get an agreement between the parties, and then in post-mediation it says enforcement of the agreement. Now, clearly that was written by a lawyer, because lawyers always talk about enforcement, and lawyers are very concerned to make sure an agreement is enforceable, because they're accustomed to thinking in terms of legal rights. Whereas in the reality, it's not uncommon for parties to reach agreements that are not enforceable. They're not enforceable in the sense that they can't be enforced in a court of law. And I gave the example before of where the agreement is we're going to start working together. Because the courts will not enforce compulsory labour. They won't enforce people to work together. So that's a bit of a misnomer, saying enforcement of agreement. But at the very least, you should have some heads of agreement where the mediator writes up the points of agreement in legalistic sort of form, so it looks as though it might hold as an agreement between the parties. So how then does the mediator fit into this role, into this sort of model? Well, in a way, the mediator is a bit like a conductor, conducting an orchestra. It's just It's the players who are making the music, but the conductor is there conducting. But you need to make sure that it's not with too much of a flourish, that you're standing back to some extent. But their job is to get the parties to the point where they continue to talk to one another. Particularly after the opening statements, they can be quite bruising, and parties can feel even offended by some of the things that might be said. So the job of the mediator is to get them into that zone, that bottom half of that diagram where they're willing to talk to one another and compromise. And sometimes they're a messenger, and sometimes when I've done mediations, I'm just going backwards and forwards between the two rooms of the parties. They have an idea, they want the mediator to explore it. It's not an ideal way of doing it. The best way is for the parties to do it face to face themselves. But sometimes the nature of the conflict is such as the parties just don't want to be in the same room with one another. Or they find it very difficult to be in the same room with one another, particularly where it involves personal relationships. So sometimes it doesn't work according to that model or any particular model. The other thing that, as I said, courses often give you a model like this. It might not be the same model, but they'll give you a model which is a framework for how you should conduct your mediations. And the other thing that tends to be emphasised, as I said, is the use of language. Because a mediator must not only be independent, they have to appear to be independent and not to be taking sides of the parties. And sometimes because of that, they've got to neutralise the language used between the parties and come up with language that is neutral, that is unoffensive to the parties. So they do that sometimes by redirecting the conversation or just by rephrasing the language used by the parties. But importantly, as I've said, they shouldn't give legal advice, even if they're a lawyer. You just don't give legal advice. In fact, in a mediation, I doubt whether you'd be covered by your insurance if you gave legal advice in those circumstances. Now, what I want to say is, now I've given you a representation of a model, but it's a fairly common model that's used. But what I want to say next is that models are useful, and they're certainly useful as a starting point, and they're useful as a fallback position. So if things are going off the rails, you can think of your model and bring it back into that model, back into that framework. So they are useful. The problem is that they don't work all the time. And of course, it's true with theory generally. Theory is a wonderful thing, but it doesn't always work in the way the theorists imagine it's going to work. So because of that, you find that different approaches have emerged, and I want to say a little bit about those different approaches. Now, the first one that was mentioned by Wendy, and one that I understand is commonly used in Hong Kong, is what's called the facilitative approach. Now, this was the original style of mediation. This is the original mediation model, where, as the name suggests, is the mediator simply facilitates discussion. They facilitate negotiation. And otherwise, they sit back and let the parties have their say, but certainly they offer no advice. So this works on the assumption that if parties will reach an agreement if they have enough information and time. If they're given enough relevant information and if they're given enough time, they will reach an agreement. But of course, that's not always realistic, because sometimes people don't have an understanding of what their rights are or what might be achievable. They sometimes don't have any understanding of what they can get out of an agreement. No understanding of what can be achieved from a mediation. The facilitative approach also assumes that the parties are in an equal bargaining position. And again, that's not always the case. Certainly there are times when you have a very dominant party in a mediation and, at least on the surface, a considerably weaker party on the other side. And particularly if you couple that with a situation where the weaker party does not understand what potentially they can obtain out of a mediation, there is a risk that they'll agree to something which is probably wholly unsatisfactory. And the trouble is, if they walk out of the room with an agreement that is unsatisfactory, eventually it's going to dawn on them that it is unsatisfactory. They'll get advice and the dispute will start all over again. So it's not productive to come out with an unequal agreement between the parties. And sometimes it's the case that parties simply don't know what they want. They're in the mediation, and they either don't know what they want or they're not clear about what they want. There was a mediation I was involved in recently, but I wasn't the mediator, I was the representing the landlord. And this involved a very large block of apartments, of units and townhouses in quite a big spread of land. And there was a dispute by just one tenant against the landlord because the tenant argued that the landlord was remiss in relation to the services provided in the common areas. The common areas are things like rubbish disposal areas, stairways, passageways, parking areas. There might be just the common areas of that. Any swimming pool, tennis courts, anything else like that are the common areas. And this tenant was unhappy with that. So they came to the mediation saying what they wanted was for the landlord to rectify certain things, certain processes and the way they did things. So the mediation proceeded on that basis, and then eventually the landlord agreed to just about everything, virtually everything, that the tenant wanted. And so the mediator thought it was all over and then said, is anything else? And then the tenant said, well, what am I getting in way of compensation? And so they said, compensation? What's the compensation? I want compensation for the disadvantages that I had because you've now recognised that things could have been improved. I want compensation because you didn't do this earlier. And this was a situation where there would have been a very slim legal prospect of this person ever getting compensation. But in any event, the landlord was clearly unwilling to even entertain that because it would mean that if they gave compensation to this person, they'd probably have to give compensation to all the tenants of the property. So they weren't excited by that. So the mediator took the tenant off into private session again, and I'm not sure what was said in private session. But whatever it was, they came back in, and clearly the mediator thought it was all resolved, and they said, right, now we're happy, the landlord's agreed to this, and the tenant said, yes, I'm happy with that, but I want compensation. And this went on for some time. Now, eventually this was settled without compensation, but it was a slow and laborious approach. Now, so that is the facilitative model, where the mediator takes very much a backseat and allows the parties to resolve their dispute. The other one that is probably of increasing use in other jurisdictions is what's called the evaluative model. And in essence, it's much the same. The focus is still on getting the parties to reach an agreement, but there's probably greater focus on that. There's probably a stronger focus on this idea that we should reach a settlement. You're here because you want to settle. That's why you're here. Let's settle. And so the mediator is likely to be more involved in making suggestions. Not in giving advice, not in giving legal advice, but they'd be more involved in making suggestions as to possible options. And while they won't give legal advice, they might make observations that are close to giving legal advice, such as if this matter goes to court, do you really think you're going to win on that argument? Or what do you think your chances are of winning on that argument? And I've heard mediators even say to the parties, do you want to settle this, or do you want to give all your money to lawyers in litigation? So there tends to be a little bit more. They tend to be a little bit more pushy, if you like, in taking a role in evaluating the position of the parties. And again, not giving legal advice, but perhaps being a little more direct or bold in the sort of suggestions they might make. So they're the two main styles. There are other styles, some of which I don't fully understand. There's the narrative, what's called narrative mediation, which is fairly new, and this is where the mediator comes in and reshapes the story that the parties tell, and in a sense, I think almost reinventing the story. And I think this is more of a postmodernist sort of perspective, and I confess it's a little bit out of my depth, and I'm not sure of all the parameters of that or how it works. Another one that has some currency is what's called transformative mediation, and that's where the mediator comes in and in some sense is focusing on repairing a relationship. And sometimes that might be the case, that you need to repair the relationship before you can get the parties into a position where they might be able to mediate. But I wouldn't encourage lawyers to be involved in those sorts of mediations. It's more the realm, I think, of psychologists and social workers. My own approach is a bit messy. It's more an adaptive approach. You adapt to your situation. You find reference to it in the literature. It's called a toolbox approach, and you take whatever tool is appropriate. Look, I think mediation, these models are useful for the reason I said, that they give you a framework, they give you a fallback position. But, you know, the reality is that people are different. Even within a harmonious society or a self-contained society, people are very different. And the way they react is very different. An approach that works with one person doesn't work with another. And it's a bit like humour, you know. You can tell a joke to somebody and they think it's hilarious. You tell the same joke to somebody else and they look at you and they think it's silly or maybe even offensive. And mediation's a bit like that. You've got to, and that is really a skill of a mediator, to be able to sum up the parties, make an assessment of the parties and think in terms of what will work here. Not what will work generally with mediation, but what's going to work with these particular parties. What's going to get them talking to one another, what's going to get them understanding one another, and what's going to get them to the point where they might resolve their dispute. Now, as I said, even in a self-contained, harmonious society, it's difficult. It's much more difficult where you're dealing with people from different cultural backgrounds. And one of the things that I've been involved with in Australia is disputes between government and Indigenous people in the Northern Territory. In Australia, we have what's called Aboriginal land, where there are areas of land that are purely belong to the Aboriginal people, and the only people who can go there without their permission are Indigenous Australians. And at times, of course, you have disputes involving Indigenous people and non-Indigenous people. So I've been involved in those sorts of mediations, but also I've had the pleasure and the advantage of going on to Indigenous communities and observing how they settle disputes, how they carry out their dispute resolution processes. And it's just totally different. There's heavy reliance on ceremony. So ceremony is a sort of a healing process, and ceremony could go on for 2 or 3 days. It's just, you go through ceremony. And for an outsider coming in, you don't understand it, but it has meaning. Another thing is the use of silence. Indigenous people are great at using silence. You can sit around in a group and nobody says anything, and you might be there for an hour, and there's absolute silence. But through that, they are settling their differences. And we don't know in our societies, we don't know how to use silence. We become embarrassed with silence. We become awkward with silence. You know, if you're sitting around in a group, if you're a very close friend, you know, you can do it. But otherwise, you know, if you're in a group of people, you feel as though you've got to say something. You can't just leave the space empty. Somebody has to talk. And in fact, as a mediator, you can use silence. You can use the Western concept and I think probably the Hong Kong concept as well, Chinese concept to your advantage, because you don't use silence. I understand it's not part of the Chinese culture either to use silence. Well, I might be wrong in relation to that, but it's but you can use it to your advantage as a mediator because you know people are uncomfortable. Western people are uncomfortable with silence. You can set up that silence. You can create silence, and the parties feel awkward. So what they'll do is often is I've got to say something, I've got to say something, and they'll say something. And often what it is, it's conciliatory. They'll come up with something and they'll say something that fills that space and is quite conciliatory. But coming back to my point about these cultural differences, if you're dealing with Indigenous people and that's the way they do it, you've got to, you throw away all these models and you just got to think, well, look, how can we negotiate this? How can we settle this? And it's not only those things I've mentioned, there's also the use of language. For example, if you talk to an Indigenous Australian and you say, you give them a proposition, you say you agree, they'll always say yes. Yes, I agree. They'll always say yes because they don't want to offend you. So again, you've got to think about how you're going to deal with that. But there are all sorts of other issues. The culture is very complex. It's very complex in the sense of who you can talk to and who you can't talk to. And there are principles about avoidance. There are certain people you've got to avoid. You can't talk to them. And if you talk to that person, you've got to talk through this person. So there are all sorts of issues also of that nature. So in those circumstances, again, there are problems, of course, with models. And you need to have a strong understanding of those cultural issues if you're going to have any chance of mediating it. I want to just say now quickly, I'm conscious that time is running out, that something about the advantages and disadvantages of mediation, or the limitations. And I'll just, the advantages can be very easily stated. One of the big advantages is the parties own the decision, and I've said that before, that it's their decision and they own it. Now in the literature, you'll see these references to mediation being a win-win. It's a common phrase, it's a win-win. There are even books written win-win. Rarely is a mediation win-win. It can be, but it's rare. It's more a case that the parties can live with that decision. It's a compromise. Everything in life is compromise. Negotiations, agreements are compromise. You're dealing with people who are in dispute. One party's not going to give everything to the other. There's got to be give and take. So the idea of mediation is not win-win, but it's for the parties to walk away with a decision they can live with and which they can own as theirs. And in that sense, it's much better than litigation, than having a judge tell you, this is the decision, you live with it. And as I said before, often at least one party is upset, and sometimes both, because they don't get everything they ask for. And arbitration is no different. Arbitration was brought in to avoid some of the problems with litigation, but in some ways arbitration's become more complex than litigation, and certainly is more expensive than litigation. And you still have the situation where you have the arbitrator telling you this is the decision, this is what's going to happen. The second advantage is it's fast and it's effective. You can run a mediation in a very short space of time. It's confidential. That's a big advantage of mediation. Unlike when you go to court, and if it's a significant case, your face might be on the front page of the newspaper on the next day, and details of your life story in the article that's attached to it. So one of the advantages of mediation is you keep that out, you keep the press out of it. A big advantage is it can be flexible. You're not stuck with court rules and procedures. You control the process. And you can be very flexible. You can have a model, but you don't have to follow it. You can be very flexible how you can use your processes. And you can be flexible in the decisions you can make. Courts can only make decisions that the law allows them to make. And the law is very rigid. Courts can't solve all your differences. They can only resolve the particular dispute you've brought to them, and then only within the realms of the law. And whereas there was a case I wasn't involved with, but I was talking to with a mediator just recently who did mediate the case, which was a big international commercial dispute, tens of millions of dollars in the dispute, and litigation had started in, I think, America, it had started in Europe, and it started in Australia. So it was litigation in relation to this dispute, or aspects of this dispute, starting in different countries around the world. And the reason it does that, of course, is because it might be that only, for example, the German court has jurisdiction over it, because it's something that affects Germany. Or it might be the American court has jurisdiction. Now, he came in as the mediator to settle the Australian component, of the dispute. But then after a couple of days, the parties thought about it, and they flew in the people from America and Europe, and they all got together, the whole lot of them, and resolved the whole lot. And they did it in a very short space of time. I think he said they did it within a week. They had all these big international disputes settled. Now, courts can't do that. Another big advantage is it preserves the relationship. One of the things you can do with mediation, if it's done well, the relationship between the parties can be preserved. And also, because they own it, the final thing I'd mention is there's a perception of fairness that is fair. Now, in relation to the downside, as with all things, there's a bit of a downside. In mediation, I don't think it's huge, and I think the main thing is the way in which they're conducted, and that might be because the skills of the mediator aren't quite what they should be, and opportunities are lost, opportunities to settle a dispute are lost. But I want to say something here about court-ordered mediations. Now, I know in some countries they haven't worked. This is where there is litigation between the parties, and the court determines that the parties should mediate. Now, I've had a quick look at the ordinance in Hong Kong that deals with this. It's a fairly soft one in the sense that it doesn't compel anything. It's encouraging of mediation, but there's no, as far as I could see, there was no compulsion. But there are practice directions of the court that give it a bit more teeth. And those practice directions talk about, well, if you don't mediate and you don't make an effort to mediate, then the court might order court costs against you, or the costs of the mediation against you if you don't mediation. But there doesn't seem to be much in the way of power or authority in the court to actually direct you. Maybe they do it still. I'm not sure whether they still do direct parties to enter into mediation, but I couldn't see much on the face of the rules that does that. Whereas the rules in my country are very specific. In Australia, they're very specific. In America, they're very specific. The judge can order you to mediate, and if you don't, there are consequences. Now, that's a good thing in the sense it takes litigation, it takes it out of the courts and puts it back into the realm of mediation where parties can settle their own disputes. So it is positive in that way. But the problem with that is how it's handled. Now in Australia it's not too bad because the courts are very flexible. Australia's been doing it for a long time, and there is now in Australia a culture of mediation. Even with all lawyers, the first thing you think about is how can we mediate this? That's the first step. And lawyers think automatically this has got to go to mediation. So in Australia, it would be rare for a case not to be mediated at all. It'd be rare. If not before litigation starts, then during litigation. So there'd be very few cases that end up getting a judgment out of a court. I'm not talking about family law cases, I'm not talking about criminal cases, obviously. I'm talking about more commercial or industrial type cases. So it'd be rare for there to be a judgment. In fact, the judges complain about it because they now say, well, being a judge is boring now. We don't get, to consider all these interesting cases. But Australian judges, by and large, handle it pretty well because they leave the parties alone. They'll say, look, go away. I'm telling you, you've got to go away and mediate, but how you do it's up to you. But if I get a sense that you're not trying hard and you're not putting your heart and soul into this, I'm going to make a cost order against you. So there's a bit of a threat behind it. The trouble is, and it works fairly well, because as I said, there is a culture. There's a culture now that's been around for a few years in Australia, and you really have to build that. Whereas in some other countries, I know, for example, in Indonesia, Singapore, and a few other countries in our region, the courts take a much more hands-on approach. Not only do they order the mediation, they tell you who the mediator is going to be, and not surprisingly, often it's the next judge, somebody from the court who's now retired, and they don't necessarily have the skills to do the mediation. But not only that, the courts often settle the mediation agreement. They'll settle the terms of how you're going to proceed with the mediation, how the mediation's going to be conducted. So in a sense, they're hamstringing it. They're confining it from the outset. They don't give the parties the chance to do it their way. So there's not the same sense of ownership. And so not surprisingly, not so many cases settle by mediation in those countries. Now, I don't know what the experience is in Hong Kong, but I know the population of New South Wales and Australia is about the same as the population in Hong Kong. They'd be both about 7.5 million. And each year, the Supreme Court alone, which is the top court in the state, would order 1,000 mediations on average in any given year. Now, I don't know what the figures are for Hong Kong. I've got no idea. But that might be just a reference point for a comparison. Of course, there are all the other courts, the district courts and the various civil and administrative tribunals, they also order mediation. So the ordered mediations are in the thousands, in comparison in the state of New South Wales. I'm looking at the time, and I won't take much longer. I just want to say a little bit about quickly who can mediate. Now, anybody can mediate is the short answer. In fact, all of you sometime in your life have been mediators, I presume. At least you've negotiated. You have a dispute with your friend, you negotiate. You reach agreement. Certainly, if you're a parent, you're mediating your children all the time. You're mediating their disputes all the time. We do it without thinking of doing it. As I said, in Australia, very commonly, they're lawyers. Not all lawyers, but I'd say the vast majority of them are. And the great advantage of having a lawyer as a mediator is they know the law. The great disadvantage is that they know the law. It's both an advantage and a disadvantage. It's an advantage because invariably disputes have a legal nexus. Everything you do has legal implications. You get up in the morning, you catch a bus, there's a contract between you and the bus company. You go to the shop, there's contractual relationships between you and the shop owner. There are property rights, permission for you to enter the shop. There are rights and obligations that are associated with that. You go to work, again, there are legal rights and obligations, not only in relation to your employment contract, but also in relation to your industrial rights under industrial law. You go home, there are legal rights with your partner and your children and legal rights and obligations. You go to the internet, you turn that on, there are all sorts of legal issues that arise from that in relation to intellectual property rights, privacy, criminal law. So most things you do have a legal context, and most disputes have a legal context. And I think it's helpful if your mediator understands that legal context, because they understand the parameters of your dispute. They understand what the consequences are if you don't settle. They understand if you don't settle, that's likely to be the legal consequence. So they can guide you through that. They can't advise you, but they can give you perhaps hints as to the legal implications. They also know what agreements are legally enforceable and what agreements are not legally enforceable. So again, it's some advantage in that sense, having a lawyer. The downside of having a lawyer is often they can't stop being lawyers. And lawyers are used to thinking in terms of legal rights. And sometimes I've heard it said, and it's probably true, that lawyers have difficulty thinking outside that box of legal solutions, and they want to bring it back to that. And it's even in this sort of thing, post-mediation enforcement. You've got to have that. You've got to have that legal context in there, and I think that can narrow the scope. That can narrow the scope of possible solutions. So it's more this emphasis on rights-based rather than interests based. So there are those sorts of limitations, but basically it doesn't much matter. The biggest, the most important skills, if you like, of a mediator is to have very strong intuitive skills and very good communication skills. And on top of that, patience. You need a lot of patience. You need to be sensitive. You need to be sensitive, including not only to people as individuals, but also to different cultural perspectives. It's good to have an open and engaging personality. That helps. I'm not saying it's essential, but it helps. And it's important to have a good understanding of the dispute. And that's why sometimes the nature of the dispute will tell you what's the best sort of mediator. If it's a complex engineering matter, then maybe you're better off having an engineer as a mediator, because they understand the technical language concern. They're able to help the flow of the conversation because they know what's being discussed. Now, just finally, I know it's 6 o'clock, I just want to say quickly a little bit about the alternatives to mediation. And there are lots of different methods. For example, in California, they've been using what they call a mediation arbitration model, which I find a bit strange, but where you have the mediator go in and is mediating the dispute. This is where there are court-ordered mediations, and is mediating the dispute. But if the parties don't agree, if the parties can't reach agreement, then the mediator goes back to the court and gives a suggestion to the judge and says they can't agree, but I suggest to you this is the resolution you should make, this is the decision you should make as the judge. And apparently the experience is that almost invariably the judges take that advice. So you have that sort of mixed role. So I'm not sure how that demarcation in roles works. How on the one hand you're removed from the dispute and at the same time you're thinking about, well, what's the resolution of this if they don't reach agreement. But you also wonder whether there's any obligation on the mediator to let the other parties know what you're thinking so that they can challenge your thought. But importantly, I think the parties would be reluctant to talk to a mediator about more personal things and more reluctant to make concessions about their case if they know that this person's eventually going to pass judgment. They're going to be less likely to cooperate, if you like, in the mediation process. Another one, and I'll finish on this note, that is becoming, particularly in the United States, that is being used as what's called collaborative law. Now, it's like mediation without a mediator. So you have the parties to the dispute, you still have your parties, and each party appoints what's called a collaborative lawyer. So that lawyer is there to support them and advise them, but it's not like normal negotiations between lawyers, and it's common, of course, in any litigation for lawyers to get together and try and negotiate a settlement between lawyer and lawyer, just leaving the parties out of it. And just saying to each other, look, here's our legal situation, I recognise yours, can we resolve that somewhere in the middle? And that's a common thing that happens. But that's not this. This is the parties still coming together. The parties are still negotiating, but the lawyers are there to support them and to advise them. And I'm not sure of the success rates. It still has a lot of the advantages of mediation because it's confidential, you're still getting the parties talking to one another, you still have the parties reaching their own decision. The disadvantage, I guess, is you don't have that third independent ear that can give you independent advice and gives you somebody to bounce your ideas off. In private sessions, you can get together with the mediator and test your ideas and discuss your ideas. But this apparently is becoming a method that's used. And one of the terms of any collaborative law agreement is that if you are the collaborative lawyer and there's no agreement, you've got to then break ties with that client. You're not allowed to represent them in litigation. And the reason for that, of course, is you don't get two bites of the cherry. You can't be thinking, well, look, if I don't succeed here, I'm still going to get a fee later on for running the litigation. So it keeps that out of it. So the collaborative lawyers have this incentive for the system to work. But I don't know a great deal about its success. I think it's relatively new. So just in conclusion, I want to say that mediation, and I know this has been a fairly superficial overview, but mediation, in my view, has huge potential. It still hasn't been fully realised, and I know, and I can't speak directly about Hong Kong, but having chatted with somebody yesterday, I got the impression that a lot of lawyers are still sceptical about it. And one of the fears, of course, you can understand that. Lawyers are afraid that their work's going to go off to somebody else. That somebody else is going to take over their role. So there is that fear element. But I think the potential is there, and hopefully it will grow in Hong Kong because, in my view, there's no doubt it's a better way of doing things. And just in my final comment, having listened to the objectives of this research project, I certainly wish it well. I think that also has huge potential, and certainly there'll be any number of people out there that'd be happy to collaborate with the department and to advance the interests of that, to promote mediation in Hong Kong. So I wish you well with that. So thank you, and thank you for your for listening. Thank you.
Thank you indeed. It's indeed very thoughtful of Professor Aughterson to have structured this talk into an area where we have an overview, so students who are seated here may think about applying for the mediation course in June. And of course...
Certainly should, yes.
And of course for practicing mediators and of course researchers here, it's very interesting to think about transformative mediation and narrative mediation, which are new ideas. And of course, I venture into the area of psychology and maybe linguistics as well.
Yeah.
So that will be some fruits for us to think about in doing it more interdisciplinarily.
Yes.
Right. So hopefully that's a good start for the year 2017. So I hope that Professor would stay with us for a few questions if we have time for it. Any questions from the audience?
Perhaps it's too late in the day for them to...
Or maybe Huda?
Yes.
One question. You pointed to the possibility mediation of maintaining or rebalancing relationships.
Yes.
Now, I'm very curious to hear your personal experiences in terms of inequality, where there is imbalance in terms of power and trust between parties. For instance, thinking about a private client standing up against an international bank.
Yes.
Do you have any comments or tips or observations that you would like to share from your own experiences?
Yeah. Look, I don't know that I have any tips. I mean, the difficulty is in responding to that sort of question is every mediation I've been involved in is unique. You do get situations where you have this imbalance, and sometimes it's difficult to manage, but I tend to take a more proactive role as a mediator. I wouldn't classify myself as a facilitator. I go a little bit further than that, and in private sessions I would talk to that dominant party, if you like, and do a little bit of reality testing with them, and maybe in that context just be saying to them, look, you know, if you want this to work, it's got to be something that works for both of you.
And use the private sessions for that.
Yeah, and use the private sessions for that. It's got to be something that works for both of you. If it doesn't, if this person leaves disgruntled, they might have agreed in principle. If they're disgruntled, the dispute's going to continue in another form. So I'd be tending to talk in fairly firm terms to that party in the private mediation, and when I'm talking in the private sessions, and when I'm talking to the weaker party, using that terminology, in the private sessions, I might say to them, look, you've got to consider whether you need to get legal advice. You don't have to continue with this mediation, or we can adjourn the mediation. But maybe you should go and get some legal advice. And I'd probably strongly encourage them to do that. But I'd first try the other party to see if they could soften their approach. But as I said, every case is different, and the responses you get are different. Thank you. Dan.
Any further questions? May I also pose one question,
Yes.
if I may? You've mentioned some new terms for describing some use of tools in mediation, such as transformative mediation, which is about recognizing parties concerned and also empower them to be able to make their own decisions. There are 10 hallmarks, and basically those are about tools. But you've just said that in doing so, particularly those are probably done by psychology background people. So you said let's be more careful. Is there a particular legal concern that has been done in, say, for example, Australia, that raised some legal concerns? Especially
In relation to that?
Yeah.
But that's again one of the advantages of having your pre-mediation conference, and you get a sense of not only the issues in dispute between the parties, but you get a feel for the parties themselves. And if I had a sense that work needed to be done of that nature in relation to one of the parties, I'd probably pull out of it. I'd probably say, well, look, you haven't got the right person. It's important that for any mediation that the right person does that. And if I have a strong sense that one party needs that sort of support and balance, I know my own limitations, and I'd just pull out, I think, at that stage.
If we don't have further questions, or if you want to stay behind and talk to Professor a bit, then we have some refreshments outside in the foyer area, so you can stay and talk a bit before we all go. So thank you all very much for coming today, and I hope to, can we show the website of our platform? I hope that you keep an eye on the update on our website, so that coming seminars that we're going to post onto it, those will be something that you'll look into, and join us in our next lecture series. So see you again very soon.
Yeah. And can I just echo what was said about taking a course? People take mediation courses for all sorts of reasons, not just because they want to become mediators. It's a great learning experience because you know that throughout your life you're going to be in dispute with people. We all are at some point of our lives. So having those skills of being able to deal with that is invaluable. So I'd recommend anybody, frankly, to take one of these courses for that reason alone. So good luck.
Thank you, Professor.
Yeah.
And one last bit, there is a bit of homework in the folder you have, is evaluation for this session. Please fill those in for us as well. Thank you very much. And thank you, Professor, again.
Thank you.